Hello, everyone. My name is Jeremy Herman. I'm an employment lawyer with Samfiru Tumarkin LLP. It's great to be back with you. I've hosted many of these question and answer sessions. As you know, I'm located in Ontario, and we have offices across the country. We have in Alberta and British Columbia, other offices in Ontario. And we're here to ensure that all of your employment law questions are answered during this session. So don't be shy. Ask as many questions as you wish, and I'll try to get to as many of them as I can. And really, in general, our goal is to educate all of you about what your rights are when it comes to the workplace. There's a lot of misconceptions out there, and we want to nip all of those misconceptions in the bud and make sure that you understand what your rights are if you're terminated or if you're having issues at work with your colleagues or with your boss. Maybe you're facing some sort of harassment. These are all things that we can absolutely help with. And if you have questions about it, like I said, please feel free to post them in the chat. Just before we do get to some questions, what I like to do is start us off with a pretty important topic that's going on right now in the world of employment law. And what we'll do today is talk about Bell. Bell is obviously a big company. I'm sure many of you know the company. And what they've done is announced a mass layoff. They are planning to cut approximately 650 management positions and 690 positions in total for non-unionized employees. And this is a massive deal. Obviously, many people are going to lose their jobs. And so, based on this, there are a few things that all of you should understand. And even if you're not one of these Bell employees, this is going to be relatable to all of you. So first of all, you should understand that you're probably going to be Bell employees will probably get offered a severance package. And that package cannot just be the same package for everybody. Sometimes when a company is laying off so many people at once, they tend to just give a very similar looking package to all employees. Well, that's illegal. The packages have to be tailored to the employee's individual circumstances. So it has to depend on each employee's age and how long they've been with the company and what kind of position they held. These are the relevant factors for how much severance each and every employee is owed when they're terminated. Okay, so this one-size-fits-all approach does not work and isn't legal. Now, when you get that offer of severance, it usually comes in a termination letter. And the termination letter will say that you get a certain amount of money and the company will make that amount even greater so long as you sign a document. And that puts a lot of pressure on employees to sign a deal for their severance pay because what the company tells them in the termination letter is that if they don't sign it by a certain time, that they're not going to get the amount of money outlined in the termination letter. So first of all, a very important thing for you all to understand is that is all nonsense. The deadlines that are in termination letters are really just pressure tactics, okay? So if the company says you have 3 days or 5 days or 7 days or 10 days, it doesn't matter. You don't only have that short amount of time to pursue your legal entitlement to severance. You actually have 2 years to do so. Now, that doesn't mean you want to wait 2 years. You want to do so as quickly as possible. You want to try to maximize your full severance entitlement and do it quickly. That is in your interest. But definitely don't feel the pressure to go and sign a termination letter just because there's a deadline in there. Instead, you should contact us. Okay, you can reach us at help@employmentlawyer.ca. I personally would be happy to speak with you. If I'm not available, there's many lawyers who are very capable at our firm who can address your questions and assist you with advising what kind of severance entitlement you have and going and pursuing that for you. Okay, so very important topic, termination and severance and deadlines. So I hope that was helpful. If you have any questions about what I said, please feel free to post it in the chat. And we'll begin with a bunch of questions that we have now. Okay, so we have a question on YouTube. I've been working at a small company for 6 years, was let go and only offered 6 weeks of severance. They said they're a small company, so they don't have to pay me much. So that is absolutely not true. You're definitely owed more than the 6 weeks that they offered you. You could be owed more like 6 to 8 months of pay, perhaps even more. It depends on other circumstances, but that's far, far more than the 6 weeks of pay. Whether the company is a big company or a small company, it doesn't change what your legal entitlement is. So absolutely, if you haven't signed a deal already, contact us at helpandemploymentlawyer.ca. This is a very basic, simple scenario that I deal with pretty much every single day in my legal practice. Employees terminated, they offered severance, not enough, and I can come in and improve that very quickly. And you really have absolutely nothing to lose by contacting us and learning more about what we can get for you. So great question, easily answered. And let's move on. So we have another question on YouTube. A non-unionized employee, 68 years old. I'm a clerk. I've been with the company for 16 years. I'm on a medical leave. You're afraid that your employer is going to come up with some invalid reasons to terminate you. Okay, do I need to go back to work? So the answer is very simple. If you are on a medical leave, you should be on the medical leave for as long as you need to be, as long as your doctor supports you to be on that leave. If you have medical documentation to support you and justify the time that you're off, then you have to be off, and your employer has to support that. Okay? They may not like supporting it, but they have to. The one thing to note is that if you are fit to go back to work, right, your doctor tells you you're able to go back, they prepare documentation for you that says that you can return to work. If you don't return to work and you quit, then typically you're going to not be owed anything, because if you resign your employment, then you're not owed severance pay. To be owed severance pay, you actually have to be terminated from your employment, or you have to be treated in such a way by the employer that it is effectively a termination. Okay, and what that would be is what's called a constructive dismissal. It's not a situation where it's so clear cut that your employer goes and hands you a termination letter, tells you that they're terminating you and offers you severance, which we spoke about earlier in this session. A constructive termination is where there's things going on at work where your employer hasn't handed you that termination letter, but they effectively have terminated you. And that could be by changing your position in a material, substantial way. Maybe they've cut your pay. Maybe they've changed your hours. They've told you you have to go to a new job location, whatever it might be. Or it could be that you're being treated really poorly and there's a toxic work environment that the employer just doesn't fix. And that's in all of those scenarios, you can treat those scenarios as a termination and pursue your entitlement. And you would be entitled to severance in those cases. But if you just kind of resign and there's no good reason for it, you just don't want to work at a company anymore, you're not going to be owed the severance entitlements that you otherwise have. Okay, great question. Let's move on. And if you have any follow-up, you could post it in the chat. So we have a good question on Facebook, looks like from Lisa. I've been on a medical leave with a return to work with accommodations from my physician. My employer said they can't accommodate my medical accommodations, but they want to have a conference call to discuss. Do I have a right to have someone present while this conference call is happening? Can I record it? Do I have to accept what they offer? I've been there for 13 years as a manager. Okay, so lots of good questions here. Let's start with the basics. If you're on a medical leave, and as I was just talking about, you can go back to work, but there are accommodations in this case that the physician is recommending and has clearly set out, then your employer absolutely has to accommodate you. If they don't accommodate you, then it is a human rights violation, and you could potentially even treat that as a termination of your employment. So, that absolutely is the case. They have to do their absolute best to accommodate you. There is a point where it's undue hardship, where it's so hard that an employer, absolutely cannot accommodate you. Maybe in those cases, it isn't a human rights violation, but usually an employer is not able to prove that. They have to accommodate you, and they have to extend themselves to accommodate you. During the call, can you record it? Well, if you're a party to the call, which assuming you will be, because you're going to be the one talking to the employer, then you can record it. That is typically okay under the law. Do you have to accept whatever they offer? No, you don't. You can just listen. Go into the meeting, do a lot of listening, hear out the employer, see what kind of arrangement they're making. Maybe they're saying now they can accommodate you. Maybe they're saying they could accommodate you in certain ways, but not others. Maybe they're saying that they just can't accommodate you, but they want to part ways in an amicable way, and they're going to offer you a separation package. You don't know what might happen on Monday. So just do a lot of listening, and then feel free to contact us, and we can have a consultation, and we'll talk about what has happened. We'll talk about what happened in the meeting, what they said, what was being proposed, and then we can guide you from there. Okay, so Lisa, that should give you some good information to go into the call. So let's move on to another great question on YouTube. Is an employer allowed to deny family accommodations if they say it is against their policy? Well, I don't know exactly what kind of accommodations you mean, but there is, under the human rights law, the requirement that an employer employer has to accommodate you for family status things. So things related to your family, perhaps it's childcare, arrangements that you have to take care of an ill family member. There are different types of things that fall under this category of family status. And if you really have a need and it falls under that category, then yeah, absolutely your employer has to accommodate it. And if they don't, then it's a termination, perhaps, and certainly a human rights violation. Okay. We have a comment on YouTube from Bro. Seems like you have an issue with a colleague. You're concerned that if you say anything or do anything about it, you might get fired or punished. So look, what you have to understand is that an employer cannot retaliate against you. So if you have a valid concern, issues with a colleague, you should absolutely you should put that concern in writing. You should approach your employer about it. If you have an HR team at the company, approach them about it. Do not shy away from that, because if your employer does retaliate against you, which is possible, it does happen, then there are legal repercussions for that. So again, if you're facing issues, don't feel like, well, I don't want to get fired, I don't want to be disciplined, or whatever the case might be. If you have a valid concern regarding another employee, maybe they're harassing you, treating you in an improper way, absolutely you should voice that concern. Okay, and ideally, as I indicated, you should put it in writing so that you can keep a paper trail of the fact that you did submit a formal complaint to the company about that. Okay. Great questions so far. Again, if anyone has a follow-up, feel free to post it. If you're joining us now or joined us recently, I'm Jeremy Herman. I'm an employment lawyer with Samfiru Tumarkin LLP. I'm here to help you answer as many questions regarding your workplace issues. So don't feel that you should be shy. Feel free to post your questions. Okay, let's take on another question here on Facebook from Olivia. My company had promised me a special performance-based bonus confirmed in writing by the CEO with the exact amount, the pay date. I plan to resign only after the bonus was paid because I have a contract that says I have to be employed. I have to be an active employee when the bonus is paid. Now the company has delayed payment without explanation. Are there grounds to claim that you're owed the bonus? Okay. So, and how do you deal with that in terms of the resignation? So yes, if you have been promised a bonus and that's even put down in writing, and the company hasn't said that, it's subject, you getting the bonus is subject to various things. They've made it very clear you've earned this bonus, you're getting the bonus, it's going to be paid on a certain date, then that is something they have to adhere to. It potentially is a contract in itself, and they have to adhere to that. So you are owed that bonus. If it doesn't say that you that it's impacted by anything, then it's something that has to be provided to you. Ideally, if you don't want to risk anything, then maybe don't resign, right? Don't resign first, because whether or not the company in fact owes you that bonus is one issue, but practically you don't want to run into a situation where they don't want to pay it to you because now you've quit and they didn't expect that you were going to quit. So you should time all of this, in a way that's strategic, of course. If you earn this bonus, you should get it paid, and then from there, if you're able to resign, if there's no obligation that you have to repay the bonus. Sometimes bonuses have to be repaid if you leave your employment within a certain time period after you were provided the bonus. So ensure that there's nothing that is in the documentation that talks about that. And if there isn't, then you're fine to resign after you get paid that bonus. And that would be the safest approach to dealing with this. And of course, if you're unsure about whether what the terms around the bonus are, will you have to repay it or not, and you need some help reviewing that kind of language, that's what I'm here for. So contact us at help@employmentlawyer.ca, and we will absolutely help you with that issue. Okay, let us turn to other questions here. Okay. I have a question on Facebook from Justin. I work in an advertising company in Ontario, and an average about 50 hours a week. I work on salary. None of my duties are supervisory or managerial. My employer says that I'm not entitled to overtime pay because I'm salaried. And you got to just work the amount of time because you're salaried. Is that incorrect? Yes, that is incorrect. You are entitled to overtime pay, even if you're not an hourly employee and you're paid a salary. So yeah, your employer absolutely has to provide you with that overtime. And if you don't perform actual managerial tasks, then even if you might have a title that seems to indicate that you're a supervisor or manager, then under the law, you wouldn't be considered one. You got to perform certain tasks. You have to delegate. There's different other categories about what defines a manager. And if you're not one, then absolutely, salary or hourly employee, you are absolutely entitled to severance pay. Okay. Let us talk about a very important thing before we move on. To more questions. So, throughout all of these sessions, we talk a lot about severance pay and what you're entitled to. You might be entitled to full 2 years of pay. Many employees are. So, how does that work? How do you know what you're entitled to? So a great tool that our firm has come up with is called the Pocket Employment Lawyer. Okay, and you can find it at pocketemploymentlawyer.ca, as you see on the screen. And you can find out how much severance you're owed. Okay, so you don't have to just guess, what am I owed? Well, use our Pocket Employment Lawyer tool, use the severance pay calculator, and it will tell you what you're owed. And you don't have to be terminated to use it. If you could be a valid current employee, maybe you don't even expect to be terminated, but you're curious to know what you might get. If you are a terminated employee, absolutely, you should check out what kind of severance you're owed. It's a free and anonymous tool, and it takes a matter of 2 minutes to fill in the details. So what you would do is you would go to the website, and it will ask you some basic questions about your circumstances, your age, your time working for the company, how long you worked there, what position you held, how much money you earned in that position. And then it will calculate very quickly what your severance entitlement is. And then from there, we will help you pursue it. You got to just contact us, and we'll arrange a time to speak very quickly. And then we will help you pursue, as I said, that severance entitlement. So, you can use the tool, tell your friends and family about it. So many Canadians have used it already, and it really does give you a really good sense of what you're owed in the event that you're terminated, or if you have been terminated. Moving on from there, we got a question on Facebook from Jordan. I just returned from my maternity leave, and my employer told me my old role has been restructured, and the employer offered me a junior role with less pay. Is that allowed? No, that's illegal. Absolutely. When you're on a protected leave, like a maternity leave or a parental leave, your employer has to put you back in the same position that you had prior to the leave. It's that simple. If the position perhaps doesn't exist, then at the very least, what the law requires is that your employer place you in a position that is quite comparable to the position that you had prior to the leave. If your employer isn't doing that, and they don't have a valid reason for it, then absolutely, if they're just placing you in a junior role, you're not getting paid the same, that's illegal. And for those of you who were with us earlier, I explained the concept of a constructive dismissal. This would be a great example of it, where Jordan's employer didn't actually terminate Jordan. They're just doing something that Jordan can construe as a termination. Jordan can treat it as a termination, and that would be saying, you get a different role. It's a junior role, and you're not going to get paid the same. If it's a pretty substantial change there with respect to what your duties are and what pay you're earning, then that's absolutely illegal. You can pursue a dismissal and get your full severance entitlement. And as I mentioned, you might be someone who's owed 24 months of pay. We would be very happy to assist you and give you an assessment of what you're owed in your case. So contact us, help@employmentlawyer.ca, and we'd be happy to assist. Okay, we've had lots of great questions today. We have a few minutes for a little bit more, so let's get to it. Okay, we have a question on Reddit from Lima. My husband was praised as a top operator and even had his work used as the company's standard. Then we found out that the company was planning to replace your husband and was training somebody else. And then your husband was suddenly let go due to restructuring. He was only offered 2 weeks of pay. And while we know that's legally all he's owed, he's trying to figure out whether hiring a lawyer for a potential claim is worth the risk. Okay, so don't jump to the gun and assume that 2 weeks is all he's owed. He could be owed much more than that. I don't know how you came up with 2 weeks. Maybe you think that because he's been with the company for 2 years, he's owed a week per year. A lot of people do have that belief. Some people believe that you're owed 2 weeks per year of service or 3. It's all not true. You're owed severance pay based on your age, your length of service, the position you held, and generally how easily you should be able to find a new job. The law says that an employer who terminates an employee has to bridge that gap of unemployment for the employee. They have to give them compensation, which we call severance, so that the employee has the financial means to move on in their life and to look for a new job. And so 2 weeks sounds like probably not enough in this case. So absolutely contact us and we'll assess whether your husband is really only owed 2 weeks of pay. It's absolutely worth contacting us to do that assessment. Usually you're not going to have anything to lose. So you can contact us. We'll give you a free assessment of what your entitlements are. And then we'll tell you how we can assist you. So don't shy away from that. Okay. Let's move on. We have a question on YouTube from Nightingale. Are you owed anything if you're let go from a contract position? Okay. So if it depends what you mean. There's a contract position where it's only for a certain period of time. So let's talk about that. You're an employee, but you are told by the employer, and maybe you even signed a contract that says you're going to be employed for 1 year. At the end of the year, you're not employed anymore. So what often happens in those cases that I see in my legal practice is the employer will continue to renew. If the employer continues to renew those contracts, then you're considered an indefinite term employee. You're not a fixed term employee. You're not a contract position. If your employer keeps giving you a new contract position year after year, it's as if you've worked that whole time in one term of employment. So that's first of all. Second of all, if your employer terminates you early and your contract says you'll be there for a year, it was never renewed. In fact, it was terminated 6 months early, for example. Well, in that case, you're definitely going to be owed compensation. So contact us and we'll help you get that. Your employer can't terminate a contract position early. If the contract runs its course and it's not renewed, then perhaps that is fine and you won't be owed anything else. That's a very great question, and we certainly see that every day in our practice as employment lawyers. Okay, that's it for today. It was great being with you. I've hosted many of these sessions, and I'm excited to be back in a couple weeks, and we'll help you with all of your questions that you have about employment law. You don't have to wait for me to come back. We have another one of these sessions tomorrow, so please feel free to join us. My colleague Lior Samfiru will be leading the question and answer session tomorrow at 1 p.m. Take care and have a great rest of your day.